Hi, everyone. My name is Brett Catani. I'm a pro bono coordinator and staff attorney with Legal Aid Services of Oregon in the Portland Regional Office. Thanks for being here today for this presentation on representing survivors in stalking protective order cases. Over the next 2 hours, we'll be our wonderful speakers will be discussing some tips, best practices, and overview of the stalking protective order laws here in Oregon. So I will give it to Debra.
Hey, thanks so much, Brett. I'm going to start, and I should have been doing this while you're talking because I really cannot multitask. I'm going to share my screen and make sure that this works first. All right, can everyone see the screen that says Stalking Protective Orders 101?
Looks great.
Okay, thank you. So first off, Trena and I are so happy to be here. So nice to see familiar names and some faces. I'll start by saying that I appreciate that folks are coming to us remotely, virtually, from wherever you're at. I know that we're still in often awkward situations where we're coming from home. My dog just ran in. There are people mowing the lawn outside. You know, recognizing that folks are coming with different things going on and different distractions. So I appreciate that folks are able to attend. If you feel comfortable turning on your camera, we would love to see faces. It's hard to present to names, although some of your names totally love, make me happy. So if you feel comfortable turning on your camera, would love to see you. If not, if you got other stuff going on, that's fine. And also, if you need to turn off your cameras to take a call or take care of something, please feel free to do so, especially if you're concerned it'll be distracting. But again, we'd love to see your faces. Trena and I are so happy to be here, and I'm especially happy to do this presentation with my awesome friend and colleague, Trena Klohe, who is an expert in this area and does a really good job making really pretty PowerPoints too. So I kind of get some of the credit on behalf of her. So also bear with me because, you know, technology, despite the years that we've been in COVID and remote and all of that, still isn't always my friend. I am going to say that the presentation is really focused on stalking protective orders, kind of 101. So we're not focusing as much on specifically the mechanics of representing survivors. I strongly encourage folks to get training in that. I know that the DVP program in particular provides some excellent training in that. I know Erin Greenewald and I and some other folks at LASSO have done that presentation. I strongly encourage folks to get training on providing trauma-informed care for survivors. But just to make a note, that's not this presentation. So please take a look at those presentations that are available out there or reach out if they need to be updated. I know some great people, Erin, who are fantastic at that work, so we can get that training for you. But today, Trena and I are going to focus on stalking protective orders. Our quick agenda is we'll introduce ourselves a little bit more, talk about why stalking matters. We'll talk about the overview of the protective order process and the elements. We'll talk about some legislative developments. The bill passed this short session that is going to impact stalking. It's going to change some of the context, change some of the criminal things, and we'll be talking about that in a little bit. And then we're going to give folks an opportunity to practice. Don't worry, I'm not going to call on anyone. I'm not going to make you even go into small groups, but I'd love folks to get engaged. I'd love folks to put some input in the chat box if you feel comfortable doing so, or just raising your hand and chiming in the conversation. And then, of course, we're going to leave time for questions as well. So to start, I'm Debra Dority. I use she, her pronouns. I am the State Support Unit Attorney at Oregon Law Center. So my job is awesome. I get to support all of the attorneys throughout the state who are representing survivors of domestic and sexual violence and family law and restraining order cases, and all of that entails. For many years, I was a legal aid attorney, staff attorney. I started in our Pendleton office on a grant from the Office on Violence Against Women. So doing this work. And I was lucky enough to move over to the Hillsborough office where I got to work with Trena Klohe, my co-presenter, for many years before moving in the state support unit about 8 years ago. So again, I love the work we do. My favorite part is getting to work with all of you. So please reach out if and when I can help. And I'm going to turn it over to Trena to introduce herself.
Yeah, so as Deborah mentioned, we got to work together for a fair amount of time at the Oregon Law Center Hillsborough Regional Office, where I've been in some form or another now for over 20 years. Originally as a staff attorney, now as a senior staff attorney, so I feel super distinguished these days. But I still want to be Deborah when I grow up. My focus throughout my 20 years at Legal Aid has been on family law and domestic violence issues. I really enjoy working on stalking cases in particular, so hopefully you will be as excited as I am by the time we're done with this presentation, though you'll also see why it poses some funky issues.
So just again, to get started and sort of orient and provide some foundation for this conversation. So why are we talking about stalking other than the fact that it's one of the, restraining orders available in Oregon? So what we know is that stalking is intimately tied to fatality and especially in intimate partner violent relationships and continued risk of further abuse. So we know that stalking is one of the top risk factors that we see in intimate partner homicides. And in fact, in intimate partner relationships, when stalking exists, there's a threefold increase in the risk of homicide. So it is really significant. What that looks like statistically, if you like numbers, 76% of intimate partner femicide victims, and just to be clear, these studies have been gendered. They have looked at female victims of male perpetrators. There's starting to be other studies out there in LGBTQ relationships and among male or non-binary or other gender fluid victims. But I just want to call it out. These are older slightly older studies, and they have not been as inclusive as we would like. But it is still significant and important to recognize that 76% of intimate partner femicide victims have been stalked by their intimate partner. And so we're talking about actual murder victims in this scenario, whereas only 67% had been physically abused by their intimate partner. 89% of femicide victims who had been physically assaulted had also been stalked in the 12 months prior. So we know that the timeline of when stalking happens is really significant to the safety of the stalking survivor. We also know that 85% of attempted femicide victims were also involved in at least one episode of stalking within 12 months prior to the attempted murder. Finally, intimate partner stalkers are the most likely stalkers to approach their victims. I realize I'm not forwarding my slides. That's why I have to look over on my other slides. See, technology. Intimate partner stalkers are the most likely stalkers to approach, threaten, and harm their victims. And again, just as far as prevalence goes, we know that I have these statistics somewhere. I believe it's 1 in 6 women and 1 in 8 men. I'm sorry, I thought I had the statistic pulled up, but I don't, have been stalked at some point in their life. So again, stalking has a significant connection to fatality and risk of further assault. All of that, take a deep breath. So we know how important it is, and now we're going to talk about some of what we can do about it. But first, this is Trena's adorable kitty. And again, this is a reminder to me to say to all of you that a lot of what we're talking about is a difficult topic. So part of being present in this meeting also means If you need to step away for your own health, if you need to step away for your own needs, that's okay too. If you need to turn off your camera to take a deep breath, to get a drink of water, please do. And if there's something I can do to help support you, either during or after the meeting, please reach out. I'd be happy to help. And now I'm going to turn it over to Trena.
Though I'm still going to need you, Deborah, to help advance the slides.
Let me know when.
Well, we're going to start off talking a little bit about the process for getting a stalking protective order, because as with most things in stalking law, it's a little bit complicated. But again, part of our goal today is to help break things down and make them manageable. But one of the first things to know about stalking protective orders is that there are two different pathways to apply for them. So the first one is a civil petition route, which is where stalking most closely resembles the process for a restraining order under the Family Abuse Prevention Act or under the Elderly Persons and Persons with Disabilities Abuse Prevention Act, even though it still has some significant differences as well. But as you can see in the slide, there's kind of a sequence of how this process goes. First step would be the stalking survivor filling out a petition, filing it at the courthouse, should not be charged a fee. The court will hold an ex parte hearing, either the day that the petition is received or the next judicial day. If court determines that there is probable cause that stalking occurred under the criteria that we'll be discussing later in this presentation, then the court will issue an order to show cause requiring both the respondent and the petitioner to appear in court on a certain date. A temporary stalking protective order will be issued in the meantime and remain in effect until the merits hearing. Once the parties do go to that merits hearing, the burden is on the petitioner to prove their case by a preponderance standard, and the court is allowed to continue the hearing for up to 30 days. And if respondent fails to appear, the court has the option of issuing an arrest warrant in order to force them to appear. Finally, if the petitioner does prevail at hearing, the court will issue a permanent stalking protective order. Officially in the statutes, it's known as a court's stalking protective order. And it's permanent in the sense that it has no set expiration date. There are situations when the order can be terminated before, I guess, before infinity, before the non-existent expiration date. Important to know that relief, the focus is on prohibiting contact between the stalker and the victim or the survivor. The relief can include an order requiring the respondent to get a mental health exam. And in these cases, the petitioner can seek attorney fees, but the stalker/respondent cannot, which I think causes some stress in the private bar, but that's the state of the statute so far. So alternatively, in stalking, it is possible for the police to initiate a case on the victim's behalf, whether or not they're actually going to pursue criminal charges against the stalker. So in the police citation route, the first thing that happens is that the officer who takes the complaint then issues a citation that requires, again, both the victim and the alleged stalker to appear in court, and it's specifically 3 judicial days after the issuance of the citation. So citation cases get into the courthouse really, really fast. But usually at that first appearance 3 days later, I guess a few things can happen. But usually if it's going to be a genuinely contested case, the court will probably issue a temporary SPO again, and then delay the full merits hearing until later. But the practices in different courts vary. So it is conceivable that the court might hear the merits right then and there. Sometimes the petitioner changes their mind. Sometimes the respondent decides they're not going to object. So again, it's important to be prepared for various possibilities. But an important and interesting distinction here is that if the respondent fails to appear on a police citation, then the issuance of an arrest warrant is mandatory. Beyond that, once the case goes to a full merits hearing and the issuance of a permanent SPO, it's the same standard as in a petition case. So it's really just two different ways that the cases kind of feed themselves into the hearing process.
And Trena, there was one question in the chat
Yeah.
about whether through this kind of route, if whether or not the district attorney's office gets involved, or if the survivor or victim is on their own.
Yeah, basically the survivor is on their own in terms of litigating the civil petition. Again, I've seen cases where law enforcement officers will both write up the stalker for potential criminal charges and issue the citation for the civil order. And certainly the DA gets involved on the criminal side of the case if that proceeds. But there's no formal role for the DA in the civil case, even though it's initiated by the police. And I believe we're getting a follow-up question on that. But Brett, can you let me know the rest of that?
Yeah. Again, along this same police citation route, the question is the police officer required to testify on the survivor's behalf?
And the short answer is no. So, yeah. And again, we can circle back to some of those more, I think, practical or strategic questions as we go. Again, there are pros and cons to each version of the orders, but the end result is ultimately the same. So next thing to talk about here is the actual elements for a stalking protective order. And Debra wanted to make sure that we had a slide that kind of contained the full version of what is required. I mean, and this isn't really even the full version still, but it kind of describes what are the elements of stalking as set out in the civil stalking statutes. So here you have it all on one page. As you can see, it's a lot. And in each of these kind of 3 items, there is a lot to unpack as well. So when it says respondent intentionally, knowingly, or recklessly engages in repeated or unwanted contact, or excuse me, repeated and, you have to kind of break out, what does recklessly mean? What does repeated mean? Then if the contacts are alarming and coercing the victim, what does that mean? Right? And it's really hard, I think, especially at first glance, to actually break this down into actionable pieces. And then also keeping in mind, we'll be discussing a case called State versus, I think everybody calls it Rangel. So I'll try to do that and not call it Rangel. But just my temptation as a former Spanish major. But the important part to that is you also have to break down whether a contact is expressive or non-expressive, because that has constitutional ramifications. So again, it's a lot. So everything that follows in this discussion is kind of my best approach to kind of, again, breaking this apart and then putting it back together in a sequence that makes a little bit more logical sense to me. And to give a quick preview, basically it's 4 parts. We're going to be looking at whether there are, in fact, 2 or more unwanted contacts. Second is whether the respondent knew or should have known that the contacts were unwanted. Third is looking at whether the contacts cause fear for the victim's physical safety. And finally, whether petitioner's subjective fear is objectively reasonable.
And I just want to chime in one thing really quickly, because Trena humored me by putting this all in one slide because it's how my brain works. And it is just, and it's relevant to the questions that we just got, which is criminal stalking is exactly the same word for word, except not intentionally or recklessly. Criminal stalking has to be knowingly. And I wanted to mention that in part because I just want to make sure folks know that if there is a criminal stalking case, that doesn't mean you cannot get a civil stalking petition. It's very explicit in the statute that the stalking petition is in addition to any other criminal or civil remedies. So that's all I'll say. Thank you for humoring me, Trena.
No problem. I will actually say that there are some other very subtle distinctions between the wording of the elements for civil purposes and the wording of the elements for criminal purposes, but functionally they're identical except for that mental state piece. So starting with 2 or more unwanted contacts, right? It's 2 or more because that's how the statute defines what repeated contact is. But there's still asterisks on all of this. One important issue is, when did the unwanted contacts take place? The civil petition statute clearly says that there's a 2-year look back period. So, you're looking at contacts that took place in the 2 years prior to the date of your petition. My sense is that practically courts apply that same standard to cases that were initiated by police citation, but that's not mentioned anywhere, except to the extent that there is some of this weird overlap between the civil stalking statutes and the criminal stalking statutes, which mostly live in the same chapter of the Oregon Revised Statutes. And stalking, usually being a misdemeanor crime, is also subject to a 2-year statute of limitations when it's prosecuted criminally.
Trena, there's a question in the chat. Does the intentional, knowing, reckless requirement apply to the resulting alarm coercion, or just the fact of the unwantedness of that contact? And is there authority on that?
That's that nuanced piece between the civil and criminal that I had in mind a moment ago. My understanding of it is that for criminal purposes, you have to knowingly cause the alarm by means of the contacts. But for civil purposes, you have to intentionally, knowingly, or recklessly engage in the contact. And then the contact has the effect of alarming or coercing the petitioner. So I think the idea for civil cases is that you don't necessarily have to prove that the stalker specifically intended or contemplated the effect of their behavior. That's really about just, did they engage in the behavior and did it have that effect on the petitioner? Another factor in stalking cases is when you're looking at contacts that are unwanted, you can look at contacts that involve the petitioner themselves or with members of the petitioner's immediate family or household. And you can see in the slide that the household member is defined in the statute in a specific way. And immediate family is also defined. Finally, as mentioned, because of State v. Rangel, we find ourselves having to ask whether a contact is expressive or non-expressive. And there's a definition of contact in the statute that is a really, really long laundry list that I'm not going to try to read for y'all in its entirety. But one important part of the definition is that it's an includes but is not limited to list. So you can come up with lots of potential contacts by analogy, even if they don't fit squarely onto the list that's already printed in the statute. But the kinds of things that might be a contact that is not expressive, right, would be if somebody is following you or lurking outside your property, your home, your school, if they're damaging your property. Expressive contacts, which again may not count, or at least they're subject to different standards here, are the things that we most intuitively think of as contact, like phone calls and text messages and letters for stalkers who are really old school. And we're going to come up on what standards apply to those expressive contacts, but the general rule is you can't use them to get to your magic number 2, with very, very rare exceptions, though you can use them as context to help explain why other forms of contact maybe were extra scary. So here is the definition of a contact under Rangel that would count as a stalking contact. It has to be a particular form of true threat. And I'll note here, just because it sticks in my craw a lot, State v. Rangel never says that the standard applies to civil stalking protective orders. It's a criminal case where the stalker was being prosecuted, potentially subject to prison time and so on, for their behavior, right? Again, similar elements between criminal and civil, but nothing in the civil statutes necessarily requires this. Nothing in Rangel, which is an Oregon Supreme Court case, specifically requires this. But the Court of Appeals repeatedly, persistently cites Rangel in applying this to civil cases. So we're stuck with it until the Supreme Court decides, hopefully one day in our favor, to weigh in on that. But as you can see, the standard is high. For Rangel purposes, your threat has to be unequivocal, right? It has to involve imminent and serious personal violence, and it has to be objectively likely that this unequivocal threat of violence will be carried out, basically. It's a hard standard to meet, but Debra will explore that with y'all a little further.
All right, so here's your chance. You're the judges, right? You're sitting there, you're deciding this stalking case. Let's assume, for the sake of argument, that the petitioner in this case has already shown you one pretty clear stalking incident, right? This is the only one they had. This is the only other one, right? They're saying to you, this is the stalking contact, and I think it rises to Rangel. So you can put it in chat. You can raise your hand. You can just unmute and shout it out. This text says, hey, you're dead tomorrow. LOL. I guess I'm going to beat the living shit out of you. Run and hide. LOL. Answer. I'd answer. I think I'm going to smash you very badly. What do you think? Does this rise to Rangel? Who wants to say? Katie says no. I hate to say it, but I think not, because it's a text message, so they wouldn't say imminent. With supporting evidence, yes. Okay. Does anybody want to share what they think they need in addition to make this meet? Either what that supporting evidence is or what that very next text maybe could say that would help them? Any brave souls out there? I'm outside. That's a good one. Violent past or prior encounters. Yeah, we'll talk about in a minute how the court is required to take the totality of the circumstances, right? So saying I'm going to smash you very badly might mean something that's unequivocal to the survivor given the context. So Lauren Guicheau says, I'm outside your house right now. I'm outside your house. I'm going to hurt you now. And they are outside. That Lauren, I think, is the winner. Like, I feel like Rangel is so high. That's about what it takes. But saying I'm coming over, a substantial step towards executing the threat, right? A time frame. Go ahead, Trena.
I was gonna say, what do we think of "you're dead tomorrow" as a time frame?
It's close. We have some FAPA case law and Buell especially that talks about imminent and how near at hand imminent is. So whether tomorrow is imminent is kind of iffy. You might want that next one to say, I'm on my way now, like we said, right?
And does anybody want to weigh in on whether the issue here is whether whether the threat is equivocal or not, whether the threat is imminent or not, or whether it's objectively likely to be followed by unlawful acts?
Yeah, I saw Carly's hand up. Carly, I don't know if that was a mistake or not, but feel free to chime in.
Well, I don't want to answer Trena's question. I actually had a
That's okay.
question. Sorry.
We can come back to Trena's question.
Okay, I'm curious if in this exchange, like what if they had like an exchange of the child that was like set for the next day or scheduled for the next day? Would that like influence it at all to make it more imminent?
I think that's a great question.
I certainly think that's an excellent argument and also goes towards the objectively likely to happen.
Yeah. I'm going to see this person tomorrow. I don't have a choice. Yeah, I think that's a great question. Kasha said, respondent made similar threats before he caused harm in the first incident of unwanted contact, right? I haven't told you what the first incident is, right? I think tomorrow should be enough when it's 2:43 a.m. if client understands tomorrow to be later today. That's good. I use this all the time in presentations. I'm not sure I ever noticed it was 2:30 in the morning. Good job. Good lawyering. Does AP have the means to follow through with the threat, right? Often we hear courts saying person's incarcerated or the person's somewhere else, right? What's the likelihood? Guess and think, lack unequivocal element. Yeah, that's good. I'm going to smash you. I mean, you're dead is one thing, but I'm going to smash you, right? Could be equivocal. Would whether respondent made similar threats before and not carried through weigh against objective likelihood? I've certainly had that. He threatened to kill her daily. He's never going to carry through with it, right? So this is not from a real case. This is something I found that I was like, this gets us pretty close. But knowing the case law that's out there, I'm not sure that this would rise to the level of Rangel. I do want you to read some threats from a real case. So 2 threats. Threat number 1. Is there a moment your wife wouldn't be murdered where she stood, leaving work tomorrow? I don't think so. See you at work tomorrow. Do you guys normally use diesel? We do. That's comment number 1. Comment number 2 is petitioner should not step to the respondent again because, quote, it may be the last time petitioner can walk. What do you think? Let's take them in turn. The first one, is there any chance your wife would not be murdered where she stood leaving work tomorrow? I don't think so. See you at work tomorrow. Do you guys normally use diesel? We do. I don't want to hazard a guess what the court said. Not unequivocal enough. The court focused on that tomorrow that we talked about. Yeah, court said not enough. The court said it's neither imminent nor objectively likely to be followed by unlawful acts. Now, a lot of what we're going to talk about, and when we do some more case scenarios in the future, obviously we're not giving you the whole context. We don't have time for the whole context. This was between neighbors, right? There wasn't a history of violence between them. So the court said not objectively likely to be followed by unlawful acts. What about the second one? The second one is almost more infuriating to me. The one where the petitioner should not step to the respondent again because it might be the last time petitioner can walk. Not unequivocal, not enough, not imminent. Because the court doesn't understand insinuation, right? The court said the threat does not meet the imminent and serious personal violence prong of Rangel because the contingent nature of respondent's statement undercuts its imminency. So as long as petitioner never steps to respondent again, they will not have a problem with it. Obviously stepping to, starting something might mean one thing, but we've seen a little bit of this. If they, as long as they don't go to this location, they'll be fine. It feels very problematic, but as you can see, Rangel is a very high standard.
The upside, sort of, is that the court is clearly very, very protective of all of our rights of free speech, even when they veer into, at the very least, super socially unacceptable and highly creepy.
Yeah. And the other thing I'll say before moving off this is just in case after case, the court says it's not enough for Rangel, but it gives context to all of these other behaviors, right? So if you have something you're concerned at all, make a Rangel argument, of course, but make sure, you have other things and use the language for whatever the communicative, expressive contact was to support the other contexts. Okay. All that important language. These are my puppies. Take a deep breath. If anybody wants to stand up and stretch their legs, get a drink of water, jump up and down to get the blood flowing, whatever you need to do. But look at these cute puppies. And then we can go on to the next. And I'll turn it back to Trena. And I
Okay.
couldn't agree more. Aaron says infuriating. I hope we continue to argue these cases though, and through our arguments, try to educate the bench. Couldn't agree more.
I agree with that as well, but do want to underscore the point that I think the most effective way to do that wherever we can, right, is to make sure you have two contacts that you can argue are non-expressive. And then when you have the additional contacts that are expressive, make the argument that they do pass muster under Rangel, and then make the alternative argument that even if they don't, they really flesh out the concerns that are driving the rest of the case. Because I think Debra told me she looked for even one example where a court did find, or excuse me, the Court of Appeals specifically, where it did find that a particular threat passed muster under Rangel, couldn't find one. So you got to make the argument, but make sure you have your fallback. So with that, though, we're going to move on to what I think of as the second element, which is that the respondent knew or reasonably should have known that the contacts were unwanted. And as we saw, the official standard is, were the actions of the respondent intentional, knowing, or reckless? Reckless is the minimum standard here, and it has been defined in case law to really focus on whether there was a conscious and unreasonable disregard of a substantial and unjustifiable risk that the contacts in question are repeated and unwanted. The simplest cases that I find in practice are ones where the petitioner sends some kind of message to respondent saying, stop contacting me, or maybe files a restraining order against the respondent, or in some other way communicates directly that there is a bright line, and after this point, petitioner should not be contacted again. But there are certainly lots of cases that don't have quite as bright of a line, but that are still compelling. These arguments are often fairly straightforward to make. Sometimes it's that the nature of the contact in question couldn't possibly have been wanted, right? Like if there's a physical assault or something like that, maybe the victim never said, don't call me again, but that doesn't mean that it's okay to show up at their house and commit violence. There are other situations where you might be able to sort of spell out that at least there was some sort of hint, some sort of suggestion. One of the examples in the case law involves really body language from the petitioner. Like you have someone following her around, getting in her path, staring at her nonstop, mirroring her movements. She keeps trying to get away. Maybe that should have told the stalker something, right? So there's some flexibility here. The next element is, do the contacts cause the victim or survivor, I'm using those terms pretty interchangeably here, do they cause that person fear for their physical safety? And this is really on both an individual level, like you have to analyze the effect of each contact in question, and then you're also looking at the collective effect of the series of unwanted contacts. So, as you can see, alarm or coercion, right? The contacts have to have the effect of alarming or coercing the petitioner. So, alarm, it's to cause apprehension or fear resulting from the perception of danger. And coerce means to restrain, compel, or dominate by force or threat. In addition, when you put them together, they have to combine to cause the petitioner reasonable apprehension regarding their personal safety or the personal safety of a family or household member. And there is case law that kind of elaborates on what this means, particularly danger, meaning a threat of physical injury, not merely a threat of annoyance or harassment. And again, that kind of ties into a theme from Rangel as well that leads to a lot of difficult conversations with clients, is that there is a tremendous amount of offensive and legitimately frightening behavior, and certainly obnoxious behavior, that may not actually rise to the level of stalking. And a big one is when there's a course of harassment that doesn't quite point to an issue that relates to personal or physical safety. Finally, in addition to looking at the question of subjective fear, right? The petitioner has to have a sincere fear of the respondent. But the court also has to find that that fear is objectively reasonable. And that's where we circle back to the totality of the circumstances. And that totality standard is one of the ways that we can salvage a lot of those expressive contacts as part of our case, right? The ones that may not count as one of our two or more stalking contacts. But if somebody is sending a lot of creepy and threatening messages, that is the context in which any other behavior should be interpreted, right? And some of it is like, a basic contact might be showing up and dropping something on your doorstep. If someone you love and trust leaves a dozen flowers on your doorstep, you might be delighted. If somebody who's been sending you incredibly gross messages for months, even when you told them to back off, that person drops a dozen roses on your porch, you might be really concerned, right? And so really pulling together what is the historical context of the relationship, what other factors went into the particular contact, in general, just what is the climate that the petitioner is living in that affects how they perceive respondents' behavior, and is that tied in some way to reality? Another way that this can come into play is, for example, if the respondent has been violent towards somebody else, and there's a record of that, or they've been bragging about being violent towards somebody else, even if you don't necessarily have that on the record. Those kinds of things might enhance the petitioner's fear and belief that this person is a genuine threat. And the court might indeed agree that that's reasonable. So Debra is going to share some additional considerations that come into play once you've gone through the analysis of the different elements.
Sorry, I can't unmute and forward slides myself. So Trena actually already mentioned this in an earlier slide, but there's a number of reasons why stalking is unique, and we'll continue to talk about them. But one of the things that makes stalking really unique is that one of the forms of relief, in addition to the general stay away, no contact like the rest of our restraining orders, is the ability for a court to order mental health evaluation and treatment if that's indicated, and also to initiate commitment proceedings if that's indicated. So again, pretty unique to stalking. The other thing that is really interesting in stalking and tends to be slightly more complicated than in FAPA restraining orders is the ability to initiate firearm prohibition and dispossession. So this is a presentation all into itself. I could speak for 2 hours on this. I'm not going to. Just know that it is possible to get firearm prohibition in a stalking case, in a stalking protective order, when certain things exist, when the parties are family or household members, as that definition is actually under the criminal law, which is almost exactly FAPA's, but not quite, doesn't include adoption. In most cases, we say you can only get this firearm prohibition if there was an order which was following a hearing for which the respondent had notice and an opportunity to be heard. But that's always the case in stalking, right? They're ordered to come to a hearing. And then the very unique thing that's in stalking, again, is that these firearm prohibitions are available, but stalking, none of the things that Trena listed in all of the elements required that the respondent be found to be a credible threat. There are obviously things that are related, but in order to get the firearm prohibition and dispossession under both state and federal law, there has to be an additional finding that the respondent is a credible threat. If you have those, you can get some of the same firearms prohibition and dispossession as you can in FAPA and a couple of our other restraining orders. Right.
Debra, we had a question from Shelby Smith. If mental health exam is ordered in the permanent order, how is that enforced? Who keeps track of whether respondent actually engages in the exam and or treatment? And I have a follow-up question myself. I've never been able to obtain mental health treatment as a condition in a stalking protective order case. And I'm just curious what other folks' experience has been trying to obtain that.
So who keeps track of whether or not respondent engages in the treatment? I think the only times I've really seen this ordered personally, this is totally anecdotally, is when there was a parallel criminal stalking case. And as part of the settlement, the respondent agreed not to contest or fight our civil protection order. And that was part of the deal the DA made, but the DA was able to kind of watch the civil protection order. And I don't know how, but they impressed it upon the respondent to get the mental health evaluation. I'll say, as with a lot of other things, if we're talking about an intimate partner relationship and there is any other type of dom-rel case, if you can say, look, they haven't engaged in that, maybe the court would be encouraged to, again, impress upon them to get the mental health treatment. However, if it is ordered in the stalking protectant order, a failure to do so is a violation of the restraining order. Do I think law enforcement will arrest for it? No, I don't. But it's still a potential to get someone engaged, to use, contempt to get them engaged in that. Do others have experience, Trena? I saw you unmuted too.
Yeah, and I think just mostly anecdotally, I feel like sometimes this has been included in orders I've worked on, but it hasn't really been a focus. Like, there wasn't necessarily pushback from the court. I wasn't necessarily making big arguments. It was just something we asked for and that made it in. And my sense is largely that this is aspirational and less enforceable than it might appear on the surface. But again, if it actually motivates the stalker to get some treatment, that's a good thing. The other context I can think of would be motions to terminate the stalking protective order, which I'll be talking about in a minute. But I think one very strong argument against terminating an order might be that the stalker never followed through on this.
Thanks, Trena. What about other folks? Have they seen it? Have they used it? And again, I think if you are having these stalking protection orders in the context of an intimate partner relationship, particularly if there are children involved, if you get an order in a stalking protective order that says they have to get mental health evaluation and treatment if indicated, and then that same person is trying to get expanded or unsupervised or something parenting time, I think it's very significant to say they haven't engaged in the treatment ordered in this case, right? And that could be in and of itself some motivation to do so. Okay. Next slide. So enforcement. So generally, violation of a restraining order, mandatory arrest rules apply, as with all other violations of restraining orders. The good news, the really good news about stalking, and it's relevant to the fact that it is so difficult to get stalking in the first place, is that unlike every other restraining order we have, right? FAPA, ADAPA, SAPO, I think, no, ERPO is a crime, but most of the other restraining orders we have, a violation is a crime. So violation of a stalking protective order is not just this contempt quasi-criminal, like in most of our other restraining orders. In most cases, generally, the first one is a misdemeanor, unless they've been convicted of a stalking crime already, or they already have a previous violation of the stalking protective order, in which case it makes it a felony. We're going to talk in a minute about how some of the changes to the legislation that we'll talk about that's going to be in effect in July actually has more ways that a violation could potentially be immediately a felony. The elements of a violation is if the respondent has been properly served or waived service of the stalking protective order, and they intentionally, knowingly, or recklessly engaged in the prohibited contact. So it's conduct, which is usually the same long list of contact that would qualify as a stalking protective order. There is within our statutes a caveat that the types of contact that are in that long contact list that are of their very nature expressive contact, so speaking to, right, writing letters, text messages, all of those are held to a slightly higher standard. Those have to cause reasonable apprehension for the victim's personal safety. So if the respondent has a stalking protective order against them and they violate it, not just by coming into the visual presence of the victim, which is one type of contact, right? That's a regular violation. But if it's by speaking or texting or emailing the victim, then that communication also has to cause the victim reasonable apprehension regarding their personal safety. That said, Rangel, that really high standard that we talked about a minute ago, does not apply. Violations that are expressive do not have to rise to the level of Rangel. That's very clear in State versus Ryan. So that's enforcement of stalking protective orders and violations. Yeah, Kasha.
Oh, I was just gonna say, I had a stalking protective order case where there was a companion criminal case and the guy was sentenced to Department of Corrections for several years and continued to write like horrific letters to my clients. And the DA told us that that was not reasonable apprehension because he was incarcerated and what more could we ask for, and they wouldn't be pursuing. And I was like, but these are additional crimes that you could pursue. And like there were threats like in the letter, but they were like, well, he still has like 5 years before he gets out. So we're not going to pursue violations. So that was a very disappointing interaction with thinking that I had like very like strong stalking protective order violations and the DA not being excited to prosecute.
That is very disappointing. I agree. I mean, I do think that DAs also and law enforcement get nervous when because as we've talked about, Rangel is such a high standard, they get nervous when it's this, held to a higher standard and potential infringement on free speech. And so I agree, but that would be frustrating. One thing I'll say, and that I think has worked to some degree, are those respondents who are incarcerated or maybe far away, but have money or third parties who are harassing our clients, who are out and about, to where maybe it's not them doing the continued violation and harassment, but our clients sure are afraid of their families, friends, brothers, new girlfriends who are around. So just as a thought for future arguments of reasonable apprehension. Kasha, did you have another question, or is your hand just still? Okay, I'll take that. Not. Okay. Trena, back to you.
Yeah, so as I mentioned earlier, stalking protective orders are presumptively indefinite. There is no prescribed expiration date. And so you sort of start from the default of they're going to last for the full lifetime of the parties. But of course, there are exceptions to that in practice. One, which I've done in at least one case, is facilitate a stipulation to a shorter period of time. So maybe someone thinks that like 5 years of protection is really what they need, but not necessarily forever. Another thing that I've seen come up in practice is just courts getting really creative because stalking protective orders make them itchy, right? Because they last a long time. They can maybe really take entrenched people and entrench them further. I think sometimes judges are just like, yeah, this sort of meets the standard, but I feel like, I don't know, like they perceive everybody as being over dramatic or something. But what that can mean is I've seen courts say, okay, yes, technically petitioner prevails, but I'm just going to set a hearing for 6 months and see if you really still want it then, right? Like, is the respondent complying with the order? Has the respondent moved away? Have you just thought better of it and changed your mind? And so you just kind of have to watch out for that sort of thing where the court's inventing a process and kind of injecting it into the stalking proceeding. Other very significant piece of this is case law has clearly established that the respondent can move for termination of the stalking protective order if it's no longer needed. again, there are nuances to this, but basically it comes down to whether there is still a basis for the petitioner to have reasonable apprehension for their personal safety, right? And one of the nice things about this, at least, is that Edwards v. Beeler, the main case, has still only been cited a few times, right? This issue has not gone up often before the Court of Appeals, so you have like a nice small handful of cases that you can read and get some clarity on the standards, unlike stalking writ large, where the case law is all over the map and it's in high volume. But things that might come into play in terminating a stalking protective order are, has a significant amount of time passed? Has the stalker engaged in treatment or done other things that would really ameliorate the original problem, right, that made them a risk? Has the stalker I don't know, just really, really moved out of the petitioner's orbit in some way? Though if that were true, there probably wouldn't really be an incentive or need for them to file to terminate this order anyway. But again, ultimately it comes down to whether there is still an objectively reasonable basis for the petitioner to fear for their safety based on all of the past history that led to the original order. Even though I think like the underlying architecture of Edwards v. Beeler, like the logic is all wrapped up in FAPA law in a way that is weird. And then that weirdness has been compounded back in FAPA land by referring back to this case recently. But the basic idea, I suppose, seems fair enough. But I do have fun litigating termination cases because it is so clear that the respondent has the burden of proof to show that the petitioner is no longer afraid of them, or that the petitioner no longer has a valid reason to be afraid of them, which is a high standard to meet. When I've been involved in these cases, often it comes up because the stalker is just like, they think they got a raw deal at the original hearing, so they're going to try to relitigate the original stalking order, and they can't do that. And when you have a lawyer stepping in saying you can't do that, then it really shifts things around. And otherwise, everybody's confused. Sometimes it's the respondent, the stalker, has just been arrested for violating the SPO, and they really think that somehow filing to terminate the order is going to give them a break in their criminal case. I think one of the original termination cases that I ever dealt with was one where the stalker, who had just started his prison sentence for multiple violations, I think got some really weird coaching from someone in the prison law library who had come up with canned forms for trying to terminate the order. It did not go well for him. But there is room in those cases for, again, some creative argument, but really, really strong case law that is generally protective of the petitioner here. Okay, another issue that comes up a lot that doesn't really have any connection to the statute per se, but certainly in my practice, is when you have stalking protective orders where the parties are co-parents. Maybe not functional co-parents in any way, but someone might be filing an order against their ex-husband or the mother of their children or what have you. And some of the problems that can arise in this are maybe obvious. I mean, the first one is just in general, there's no guidance in the statutes, and there is no authority to include a parenting plan in a stalking protective order, though I've seen at least one judge try to do it anyway. And I think the reason why they did that is because of the next problem, which is that a stalking protective order, if everything is done just strictly by the book, it can operate as a de facto bar to the exercise of custody or parenting time, which, respondents are not happy about, courts are often not happy about, and may in fact also be a disservice to the victim, because parenting disputes can be a really powerful incentive to violating a stalking protective order. And that's if the order is issued at all, because judges are so reluctant to really disturb parent-child relationships, even when one of the parents has stalked the other parent. I think this also involves potential constitutional issues that, as far as I know, have not strictly been litigated about sort of the right of parents to be parents under constitutional law. But so it creates practical problems with no guidance pointing in the direction of what should you actually do. So I'm going to propose the solution that I use in my cases that I think of as best practice, which is just to ask the judge to put language into the stalking order that expands on the general instruction not to contact petitioner. It's kind of tricky now because the standard form of stalking protective orders removed a lot of blank space where courts were sort of feeling empowered to write in whatever they wanted. And it's probably good that in general, it just defaults now to, you are not allowed to contact the petitioner. Here's a list of things that might constitute contact. Don't do it. But thanks to Adobe, even on the new forms, it should be fairly manageable to have the judge interlineate provisions that basically say, notwithstanding anything else in the stalking protective order, that for purposes of exercising parenting time with the party's child or children, that respondent may have incidental contact with petitioner to the extent authorized by a valid domestic relations order or judgment. In cases where the respondent is otherwise consenting to the issuance of the stalking protective order, they've kind of given up, or where it's contested, but we're just asking the judge to do this. I have a good track record with courts being willing, and I think probably pretty happy to include language of this type in the stalking protective orders. I like it when they use my language instead of doing something a lot squishier. And I think some of the benefits of doing this is that it does carve out space for the respondent to exercise parenting time when that is otherwise appropriate, even if it's in some limited basis, without purporting to give the respondent an enforceable right to exercise parenting time if the family court hasn't dealt with that separately, right? This language is also general enough that you don't have to go back and ask the court to modify the stalking protective order over and over and over every time there's some other change in the family law front. And again, I've seen some stalking protective orders that sort of start out saying, okay, respondent can have contact for this purpose on the schedule. And again, once you have a schedule in there, then you're kind of locked into something that you're going to have to try to change down the road as a rule. So better to be general here and just kind of have this blanket cross-reference to whatever the family court is actually going to be doing. At the same time, the existence of the stalking protective order can and should still influence decisions that are made by the family court at any time after the stalking protective order is issued. And hopefully it is also obvious that when there is a stalking protective order in place, if the parents are also litigating custody and parenting time, that parenting plan should be very clear and very specific so that you need to know where the lines are so that you know when the stalker has crossed them. But having some room for the stalker to continue being a parent, again, is to some extent an important safety valve for petitioner themselves, and it helps allow for other policies of the state in favor of parents to remain undisturbed.
Thanks, Trena. So as mentioned before, there are some new, there's a bill that passed in the short session just recently. It's House Bill 4156, goes into effect July 1st, that changes and kind of modernizes the stalking bill, or the stalking statute. The whole point of this bill is really to modernize, given how significant technology is in stalking. And we didn't really talk about it before, but one of the plugs we'll make in our resources is for a great program called Spark. They have a lot of great resources for your clients, for you. They have a judge's bench guide that they recently put out with NCJFCJ, National Coalition of Family and Juvenile Court Judges, a bench guide. We also did a bench guide. Sorry, I'm getting ahead of myself, but just the recognition of how significant it is that technology is used in stalking, and we'll talk about that. So one of the most important things this bill does is it expands the definition of contact. When I mentioned this to Trena, I'm like, we have to talk about this. She's like, it already says includes, but not limited to. So these are all already in there. And I'm like, yes, totally agree. And so if you don't see something that's contact on the list as it is, and you think this person is definitely contacting my client, it's not on the list. Remember, it's including, but not limited to. But this bill makes it really explicit that identity theft, which is that converting to one's own use personal identity of another, disseminating an intimate image. So I want to make a plug here. Often what's that term is used for that is revenge porn. I want to make a plug that we stop using that term for a number of reasons. One is because revenge is something you take on someone who's done something wrong. Survivors are not doing anything wrong in this case. And a number of survivors whose images are being put out there on the internet or being spread around, would not necessarily think of those images as pornographic. So I want us to shy away from using that term. Sorry, I'll get back down off my soapbox right now, but the stalking contexts are expanded. Dissemination of an intimate image is explicitly one listed. Electronic monitoring or tracking, not just with GPS, but GPS is included in that. There's some case law already out there that says that is included in a contact, but to make that explicit in the list is really important. This causing a third party to harass, humiliate, injure by disclosing personal information. The term we use for that is like doxing, right? So all of these are now in the list of contact starting July 1st, but you don't have to wait till July 1st, as Trena pointed out. The list is including, but not limited to, the stuff that's already in the statute. I think this just makes it really explicit. The other thing that this bill does, and again, we're not focusing today on the criminal elements, the criminal side of stalking, but you should note that the felonies, that the crime of stalking moves from a misdemeanor to a felony when the dissemination of an intimate image is one of the types of stalking, when GPS tracking is one of the types of stalking. If any of the violations are felony in and of themselves, those are also increases the actual violation from just a misdemeanor to a felony. And in addition, just the crime of stalking itself moves from just a misdemeanor to a felony if some of the contacts are some of these newer ones that are put on the list. So just a note to say that there's more in the list of contacts with this bill, recognizing sort of technologies being used to stalk and the sort of new brave new world we're in that stalkers are using against survivors, but also it has some good impacts on the criminal stalking and the violations of the stalking protective orders that we're talking about here as well. Trena also made me put case law updates pending because I do and have in years past created and updated our case laws of all the stalking protective orders out there. I've been a little lax in part because there are so many, but she said, I'm going to put it on the slide anyway, so you have to promise us that you'll do it. So I'm going to promise to do it soon. Notice there's no date, just says pending.
Yeah, not a lot of pressure on time. Just, again, another aspiration, because when you do put those out, they're so helpful to all of us.
Thanks. So now we're going to get to do more fun stuff and try some practical scenarios. So I want to start with one of the scenarios, just like the first one we did. Please chime in, raise your hand, unmute, put something in the chat. But let's talk about these cases, right? Let's talk about some stalking cases. And if you have seen this case law and you're very familiar with it, don't necessarily give it away unless nobody's talking, then chime in. Okay, scenario number one. Imagine the parties are in the middle of a custody matter. Petitioner is repeatedly told respondent not to contact her unless it's regarding their son. And the following occurs. The respondent violently confronts petitioner during a child exchange and actually injures petitioner. Small injury, but injures petitioner. The respondent places a tracking device on petitioner's car to track petitioner's movements. The respondent drops the child off in an exchange and pushes himself into the door such that petitioner actually has to force the door closed, calls petitioner a whore in front of their son, and then goes around to the back to where the back porch is before finally leaving. So my two questions are, one, are these qualifying contacts? And number two, do you think they're sufficient to cause petitioner objectively reasonable alarm? Remembering our definitions of alarm. Who wants to chime in? Does me making myself be okay with silence?
Yeah.
Nobody who wants to be brave enough.
We have a few comments in the chat.
Oh, okay. Thanks. I can see the chat. Yes and yes. One person says these are qualifying contacts and they're sufficient to cause objectively reasonable harm. 1 and 2 are probably qualifying. 3 probably not. So the violently, the injuring, and the placing a tracking device. Okay, good. Anyone else? The answer is yes. They are qualifying and they were sufficient to cause petitioner objectively reasonable alarm. This is the case CLC versus Cordell. And the court, often in these cases, I was telling Trena this when I was trying to find a good example of a Rangel case, but every time I thought there was a good one, the court was like, well, we can't find another one. So even if that's the only one, it's not enough. So we're not going to talk about it. So they would kind of punt. But if I remember correctly in this one, they did look at all 3 and they were like, it's pretty sufficient. But again, a lot of it is context, right? So there was more information, the fact that the parties were in the middle of a custody matter, there's some history there too. Okay, good job. Next one, scenario 2. Petitioner respondent or divorce, joint children. Respondent has access to firearms. Petitioner files for a stalking protective order based on the following. The respondent rammed, bumped, or tapped into petitioner's car 3 to 4 times while petitioner was picking up the joint child from the respondent. And the respondent drove by petitioner's home and stopped to take photos of petitioner's home with the cell phone through the window of his vehicle. Are they qualifying contacts? Are they sufficient to cause petitioner objectively reasonable alarm? No. court would say the second is not qualifying. Yes, and maybe. Okay. So there's some sense that folks feel like the first one, hitting another person's car with your car, that feels pretty scary, pretty alarming. Maybe even a crime, right? So context can be committing a crime against another person. So the court said, yep, that one applies. But only the first incident. This is a good example of a case, however, that I think is really important to understand context. So this case is JDB versus Mueller, and the court said the first incident was sufficient, the second incident isn't sufficient. However, there's a previous case, Pinkham versus Brubaker, in which the respondent was driving by petitioner's home slowly and looking at her home through binoculars. And the court found that that was a sufficient context for stalking. But the reason why, in part, was because the parties already had a FAPA, right, in the case. So the petitioner had a FAPA restraining order against the respondent in that case. So driving by slowly with binoculars has this different sort of, feel to it. And in fact, the court in this case specifically noted that the petitioner expressed concerns that the respondent had access to firearms, but didn't, the exact words, provides no evidence that respondent ever threatened her with firearms, right? I mean, what we know about domestic violence is the presence of a firearm increases the likelihood of a homicide by 500%, but we know that. Not all judges know that, but we're working on that too. But so being able to pull that in, right? What exactly was it about the firearms that caused her concerns? What other conversations had there been about that? So totality of the circumstances is really significant. Trena?
I just wanted to underscore that the takeaway from this case is not that there is a huge qualitative difference necessarily between binoculars and cell phone in a drive-by, but that really fleshing out the context that occurred in makes a difference.
Yeah, totally. Thanks, Trena. Okay. Number 3, the parties are college students. The first contact, respondent introduces themselves to petitioners saying, I've been watching you and I felt like I needed to talk to you. Petitioner says, not interested. I don't want to give you my phone number. In fact, I think she says, I got a boyfriend. Thanks. A month later, the respondent rushes up to petitioner in a shop, explains that I saw you at a club the other night, and this is what you were wearing. This is who you were with. This is how many drinks you have. And then grabs her leg while they're sitting there talking, grabs her thigh. She immediately stands up, gets her order, and leaves. She starts to get worried. She has friends walking her to class all the time because she sees them all the time. She says she sees him everywhere, even on one occasion, trying to get into a private event that she was at. She saw him trying to get in. You had to have tickets. And then on another occasion, petitioner is walking shoulder to shoulder with a companion when the respondent pushes himself between the two and grabs her waist. Right? So are these qualifying contacts? And I want to say the third one I kind of put in there just for context, not so much a contact. What do folks think? Are these qualifying contacts? And are they sufficient to cause petitioner objectively reasonable alarm? And it says seems unlikely. No, but yes, I like that. I agree that I don't think a court would find these objectively reasonable to cause alarm. 2 and 3, maybe. Yes and yes. Number 1 probably doesn't qualify because he doesn't know that it is unwelcome. I think that 2 and 4 do qualify. Yeah, kind of number 1 is given context too for that, like, unwanted, leave me alone at that point. Agree with Charlie. Yeah. Right. So this case surprised me when I read it because the court said this is a close case, and it was a close case because this guy was talking to her when he would go up and have these contacts with her. So like it was a close case because a lot of the contacts were conversations he was having, but they found that it qualified. So one of the things I think is interesting about this is that they are strangers, right? And as much as we talk about, you know, stalking in our world, a lot of the times we talk about it as if it's a stranger or someone you don't really know, even though that we know that the vast majority of stalking contacts are an acquaintance or in a personal relationship with an intimate partner or former intimate partner. It's like 40 and 46%, right? Or acquaintance and personal relationship. So the vast majority together are definitely people you know. So I just wonder if the context where these folks did know one another, if this would have a different sense of it, or if it somewhat felt a little scarier because it was a stranger. Again, I want to recognize that I know I'm not giving you all the context of all of it, but this case is CQR versus Wafula. I'm not positive I'm saying the last name right. It's Wafula. The court noted that viewed in isolation, the second incident would not be objectively reasonable for petitioner to perceive as a threat, but viewing the circumstances as a whole, the evidence was sufficient for a stalking protective order, even if respondent didn't intend to harm the petitioner. So that was he grabbed her by the waist on that occasion. That was that occasion where didn't intend to harm her. He was like, oh, I was making a joke. I often bump into my friends when I see him on the campus and they think like rude. And then they see it's me and they laugh. That's all he was doing. Right. But given the context, the court says it was a close case, but this qualified. Okay, go ahead, Trena.
I was going to say that's another example of where that mental state issue comes into play that is somewhat distinct from the criminal standard, right? Is that he didn't have to intend to harm her. It was what she experienced about it, but he did knowingly engage in the contact.
Yeah,
Or at
knew
least
it was
recklessly
unwanted.
disregard its unwantedness.
Yeah. Thanks, Trina. Okay, last one. I'm gonna stop put you on the spot. Parties are students at the same college. They were dating for 18 months. The respondent has trouble accepting their breakup. During the 24-hour period, shortly after their breakup, he initiates 103 calls and text messages, but none contain threats. The respondent walked towards the petitioner in public, then obstructs her path. Respondent shows up at a home where petitioner is house sitting to display self-inflicted lacerations on his arm. Petitioner threatens to call the police. Respondent moves his car near petitioner's whenever she is parked on campus and shows up at petitioner's work. The respondent allegedly scrawls pedophile across the garage door of a petitioner's friend's home. The context for that is petitioner had a friend who was an elderly gentleman. She went to go visit him often. The respondent got it in his head that she was having a relationship with these elderly gentlemen and did not like it. So wrote graffitied pedophile on his garage, allegedly. What do folks think? Are these qualifying contacts? Are they sufficient to cause the petitioner objectively reasonable alarm? No, yes, no. Probably not. It's all due to the intimate relationship. Anyone else want to chime in? Maybe, yes, and no. Okay, Aaron Greenwald, the first one, no, but gives context. The last 4, yes. And then I think a lot depends on what he was saying when he showed the self-inflicted injuries, right? And again, this is hard because I'm not giving you all the context. Like he shouldn't have known where she was house sitting, so that's a little creepy, right? This case is HLP versus Jones, and the court said no, not enough. The court said it did not cause objectively reasonable apprehension regarding petitioner's safety. The worst. So all this to say, I'm not really sure it's clear exactly what the stalking, what a court would find to be sufficient in stalking cases. They're hard. It's a high standard. There are some unique things I just want to throw out there for some of the other things that we've talked about. One is expressive contacts are especially tricky when you're talking about things like leaving letters on a doorstep. I would want to say the leaving of the letters on the doorstep is a contact, is a scary contact, but because it's actually letters and they're expressive, that has to be held to the Rangel standard. Also, picking up the phone and breathing heavily into the phone is not expressive contact. So that can be used as just a regular scary contact, doesn't have to rise the level of Rangel. One other thing I think is important is that there's at least 2 cases that say that the contact, when learned about, is when it needs to cause the person, the objectively reasonable apprehension regarding their physical safety. So one was an example where the petitioner's clothing, the respondent had torn up all the petitioner's clothing. She didn't know that right away. She found out about it much later. But when she discovered it, that was scary. The same with the tracking device. It had been in the car for a long, long time. And it wasn't until afterwards, once the petitioner figured out about it, that they had that reasonable apprehension. So just to mention a few of the other nuances. But yeah, I mean, I think that this is tricky. I tried to give some of that other context, like he's hyper-focused on her. 103 calls wouldn't have rose to the level of Rangel because there wasn't the threatening, but that feels like a lot. So, this one, especially in comparison to like the campus one, feels a little strange to me. I'd encourage folks to read through cases. Unlike at the Court of Appeals, where fact matching, they don't want to see fact matching and let's try to fit things into the exact thing, to the exact other case. I think it's different at the trial court where we want to say to a judge, this case is like X case where the stalking protective order was put in place. So again, stay tuned for those case studies. And also one of the resources that we're going to talk about. Oh, one of the resources we'll talk about in a minute, but first look at this cute lamb and take a deep breath because that was difficult stuff to talk about, especially when we feel like the court isn't getting it right, and how that feels to be fighting for these and to recognize that we don't always have the power to get the right decision. So take a quick break here, breathe. Neither Trena or I have this cute lamb. Trena just got a cute lamb off the internet.
Thank the Microsoft gods for adorable goats.
Goat. Is there a different goats, lambs? Different? City Girl. Katie, I saw you unmute for just a second.
The baby goat is a kid.
Baby goat is a kid.
Yes.
And goats and lambs are 2 different things.
Yes, because a lamb is a sheep, a goat is a goat.
Oh.
You should have asked me for some of my baby goats and sweaters pictures.
Maybe you should just send those to me just to have.
I will do that.
Thanks, Katie. Okay. So we want to share resources now. One of the important resources that I'm really proud of, and I know some of the folks on this call have helped with even, is the Stalking Bench book. So as many of you know, there's a FAPA bench book. Stay tuned. Literally tomorrow is the last day for people to get to vote on that. And then I hope to announce that the FAPA bench guide updated for 2024 will be available. Stay tuned. But the State Family Law Advisory Committee Domestic Violence Subcommittee created a stalking bench book. So if you're unfamiliar with that, please take a look at that. It has a lot of great resources in it, as well as going through the stalking laws, both protective order and criminal. It's a couple years old now, so it doesn't have all the new case law, but I will send that case law out. There's also an advocate guide through our Oregon Law Help website, and the updated comparison chart. So if you aren't familiar, our comparison chart has all 5 protection orders in Oregon, and compares them all, the eligibility, the firearms prohibitions, all of the different aspects. It goes into quite great detail. So it's definitely meant for, attorneys, advocates, legal support staff, to help, not necessarily to hand over to clients or survivors who are trying to figure out what the best option is. Those are both at our Oregon Law Help location. Many of you may know that our Oregon Law Help is migrating to the bar's portal project, which is a joint project between the bar and legal aid and OJD.
Technically has migrated. It's now in updated format.
Housing and family law have migrated. So so not all of the stuff, but the stuff related to what we're talking about today. And you just want to mention that a lot of the resources that we used to have available that were much more detailed, like pamphlets and booklets and advocate guides like this, they're under the practitioner's guide. And actually, Trena, you might put that in the slide.
There's a link to that at the end of the slides.
Okay, there's a link to that at the end of the slides. So I want to mention 2 other resources that aren't specifically about the legal response to stalking necessarily. So SPARK, the Stalking Prevention Awareness Resource Center, is a sort of, it used to be the stalking, it's the national organization that supports stalking. I can't remember what it is, but what it used to be, but they recently changed their name to SPARK. They have a lot of really great resources. So if, like we often do, you're meeting with a survivor and you're like, oh, I'm really worried that you are being stalked right now. I don't think you have enough, because I just went to this presentation and the court's never gonna, take enough expressive contact or whatever, but I'm really concerned for your safety. There's a couple of things to do. This website has a incident and behavioral log that might help the survivor, indicate what the stalking contexts are, what concerns they have. It also has some safety planning materials. So I would encourage you to share those materials and the resources that are on this webpage with them as well. It also has a stalking bench book for judges, and a stalking bench card that goes into sort of a lot more general, some statistics and the gravity of stalking that we've talked about, and has like some really great language about language that can be put in criminal stalking release agreements and that type of thing, and findings specific about stalking. So I'd encourage folks to take a look at that. If you are on a local LFLAC, a bench bar committee, if you have any connection with your local judges, share both our local Oregon stalking bench book and the SPARK stalking bench book, because I think they're both really great resources that speak to judges' work specifically. SHARP is the Stalking and Harassment Assessment and Risk Profile. It's basically a risk assessment. So many of you are probably familiar with like Jacqueline Campbell's danger assessment, which is about the likelihood of a domestic violence fatality, or ODARA, which is a risk assessment. It's the likelihood of continued abuse and domestic violence or intimate partner violence. SHARP is specific to stalking, and it's not necessarily meant for, well, they have a lot of really important disclaimers about like this shouldn't take over someone's intuition, but it does help sort of get a big picture of the situation. And I'd encourage folks to think, when we meet with survivors, they often don't come to us and say, he's stalking me, or she's stalking me, or they're stalking me, right? In fact, what we often hear is something like, I'm nervous about this behavior or this harassment. And in fact, we sort of save stalking for these very rare, very scary and very serious situations, but are these stranger stalking situations, right? Or someone I don't really know stalking. And so oftentimes survivors will come to us and say, I'm being stalked, right? Maybe I'm being harassed. Maybe I think I'm being followed. So the nice thing about this risk profile, the SHARP profile, is it can help you get a big picture of what is happening if you can kind of go through it with the survivor you're working with. And again, that could help them safety plan, especially if you're in a situation where either you can't represent them or you don't think that there are sufficient, contacts as of yet to get a stalking protective order in place. So I'd encourage folks to take a look at that profile, use it to sort of flesh out more with any survivor you're working with. I'm trying to hurry in case there's more questions. For survivors specifically, obviously we have statewide forms for stalking protective orders. We see very few law enforcement these days do the citation route. So, certainly survivors can go to law enforcement, report stalking. Hopefully law enforcement will, engage a criminal case when appropriate and maybe do the citation, but we do see a lot of officers or law enforcement say, well, you can file it on your own. They can, that's good. It's available. We also, on that website, like I mentioned, the Oregon Portal, the Portal Project, we have our How to Get a Stalking Protective Order little pamphlet. So again, if it's someone you're not able to support fully or not able to represent fully, or if you just want to provide that brochure that has a little bit more information, that's still on that website. The National Network to End Domestic Violence, they have a tech safety program that really are the experts on technology safety. And one thing I want to impress upon folks with this link is that if survivors are saying, my stalker is showing up someplace and I don't know how they know I'm there. They seem to know my movements. They seem to know all of this. There is a ton of really good information about how to protect one's phones or other technology from potential technological stalking. They have, apps you can download. They have ways to look in your phone or in your technology, things that are way beyond my knowledge and comprehension, but they have guides specific to survivors to really make sure that you're not being stalked through your phone or through your other technology. And then I think I already mentioned the incident log, safety planning, hotlines, and more on the Spark website for survivors specifically. And I think that, I'm going to let Brett talk about this.
Hi, we do have a question, but we could discuss that after this slide, if that's okay. So I want to talk a little bit about our Legal Aid's Domestic Violence Project. And first, I want to thank the volunteers and legal aid staff who've dedicated countless hours of service to survivors through the Domestic Violence Project, or DVP, which is one of several volunteer lawyer programs operated by LASSO. Basically, the project maintains a panel of volunteer attorneys and matches pro bono attorneys with low-income survivors of abuse, stalking, and sexual assault for advice and representation in contested restraining order or protective order cases. Primarily, we largely see the Family Abuse Prevention Act restraining orders. It tends to be the largest ones that come in, also the EPDAPA, but then also we do get stalking protective order cases like this as well. And so thank you so much, Trena and Debra, for your work on this presentation and sharing your expertise and wisdom. So really quick, just kind of a little bit more about the Domestic Violence Project is LASSO staff assists with client screening, information, and documentation collection, and compiles a pro bono case file for our volunteers. No specific legal experience is required to volunteer with legal aid, and the majority of our volunteers with DVP are not family law attorneys. Legal aid provides mentorship and support to volunteers. We strongly encourage volunteers to reach out when questions come up, or if you'd like to talk through a case with a subject matter expert. We're always happy to talk with our volunteers or connect that volunteer with a private attorney for further assistance. Almost finished. LASSO and OLC are both certified Oregon State Bar pro bono program providers, and therefore we can provide PLF coverage to attorneys who don't have insurance. Also, the resources that Debra and Trena showed in the last couple slides, as well as the slides from this presentation and a video from this presentation, will be available on probonooregon.org as well. Trena, Debra, have I missed anything? No.
I don't think so. I will say that my role at Oregon Law Center Legal Aid is to support all of our legal aid attorneys, Oregon Law Center attorneys on these cases. But as Brett knows and Shelby knows, if you reach out and you have a complicated issue, if you're volunteering, if you've taken the case through us and there's something I can do to help, and I will pull in the other expertise of Trena and others in our organization to find out, I'd be happy to help in case that is a motivator to take these cases. And then we have a question.
Oh, yeah, it's the question. Melissa Haggerty asks, perhaps this is a dense question, but if a person has a qualifying relationship, like the last example for a FAPA, wouldn't it make most sense to guide a client toward a FAPA with potential renewals rather than an SPO due to the much more rigorous standard? So FAPA versus SPO.
Excellent question. So such a great question. So thank you so much for asking it. I'm going to give my input and then I'd love to hear Trena's input too. I would say this. Number one, it all depends on the situation, right? And so if there are children involved, like Trena was saying, we have judges that try and fit in parenting plans and all of that in Stalking. They don't really go there and it doesn't really fit there. So if you have a custody or parenting time issue in a case, I'd really probably want that immediate relief of a FAPA order. Please, though, know you can get a FAPA and a stalking order. There's nothing that stops both of them. The benefit of stalking, as we've discussed, is that they're indefinite, is that violations are crimes. They're not just contempt actions. That said, we also know that sometimes when we file for protective orders against respondents who are engaged in this dynamic of power and control, if they win and the stalking order is dismissed, sometimes that emboldens folks, right? And so I think going forward with a strong stalking case, if you are pretty confident or a really good argument for a stalking case and have a pretty good argument for a FAPA case, there's nothing that stops you from going for both. Remember, the only restraining order in Oregon that you cannot get if you have any of these other restraining orders is the sex abuse protection order. So obviously, if that's the other one you're considering, think through, what needs to be filed first and what you can and can't do. But I think that's an excellent question. I think it's a case-by-case basis, but there is nothing that says you cannot do both. Quick plug, FAPA is now 2 years. Right? So you get it for 2 years. If you get it renewed, you get it renewed for another 2 years, right? So that does feel a little bit better too when you have a survivor who's trying to get through a dom-rel case, right? Getting the 2 years lets that temperature go down, lets the dom-rel case go through and maybe even get finalized. So I think it's an excellent question. I'm sorry to give the answer of it depends, the lawyerly question, but it's true. I'd love to see what I've forgotten that Trena has remembered.
Well, first, I just want to affirm, yeah, it really does depend on what's going on in your case, what strategic vectors are involved, what the client's energy level is for different things. And I just note that in addition to FAPA, there's often a fair amount of overlap with ADAPA cases as well. And really between FAPA, ADAPA, and stalking, right? There's a pretty robust Venn diagram of when, someone might qualify for one or two or all three kinds of order, and it's a real mix. On occasion, even when there is a qualifying relationship or a qualifying status as an elderly person or a person with disabilities, there are times, though they're rare, when I think a stalking protective order might actually be the best fit. And I think that might have come up in the chat just now. Some of that is when you are looking at incidents that where maybe the most egregious behavior is more than 180 days old. You probably still want to be able to show some sort of rationale for filing now instead of some time ago, if that's the situation. But it matters. There are situations where I've had clients who are really motivated to file for a stalking protective order, that might be on that fine line that could go either way, which, as we can see in the case law, there are really fine distinctions that get made, and they're not always obvious from one case to the next. So many times I do encourage clients to file for another protective order as kind of a fallback option there. And when children are involved, as Debra said, there's often a lot of upside to filing for a FAPA and getting an immediate and enforceable parenting plan, and whether or not you move forward then and also get the stalking protective order. Certainly SPOs tend to involve sometimes much more intense litigation, a lot of resistance, less certainty about the outcome, pushback from judges, more likely to be appealed, more likely to be overturned on appeal. I don't have the stats necessarily to back that up, but that's certainly my anecdotal understanding of the situation. But again, some of what you also have to be thinking about is how strong is each case and how much trauma is someone reliving, either by handling both cases at the same time or by facing the prospect of having to renew a FAPA many times over, often with kind of diminishing odds over time. But when in doubt, that's certainly one of the many kinds of questions that I'm happy to explore with people. And then I'm sure Debra is as well, is like, what is the right strategy in a given case? And is it obvious?
Yeah, I'll just, the last thing. So thanks, Trena, and Lauren too. I knew I'd forgotten something. But the other thing I'll say is some judges really hate to see stalking cases in family or household relationships when there are kids, right? So kind of knowing the pushback of the judge too, but that's why I say don't shy away from having more than one if the, client and the survivor you're working with you think is comfortable with that and the pros and the cons of that. I don't think ever in my life I've finished slides with time. So if folks have more questions, we actually still have like 4 minutes.
We do have one additional question.
Okay.
And it might have been mentioned, but is it possible to ask to combine hearings for multiple kinds of ROs?
Yeah, and like Kasha said, yeah, I've done it for FAPA and stalking. The only caution I will say is just really make sure that there are different, that it's very clear that there are different standards that you're proving each one of them. So earlier I mentioned that in stalking, you don't have to prove credible threat, right? Except to get a firearm. There were times when we had previous forms where we had that credible threat finding in the forms, because in the case that someone wanted to request the firearm prohibition and dispossession, And judges were saying, well, I don't think there's a credible threat of further abuse. I don't think the respondent's a credible threat of further abuse. And so the stalking protective order wasn't getting ordered, right? But that's not a finding necessary. So I think you absolutely can. Just be really careful that you're parsing out which elements go with which. And then yeah, what relief is ordered and what.
Yeah.
Yeah,
And alongside that, I want to put in a real strong plug for hearing memos. I think especially important in stalking cases because context matters so much, and a hearing memo is really your chance to kind of tee things up, and hopefully kind of predispose the court to hear the right things
Yeah.
in your evidence. But if you have a case where you are bringing these somewhat distinct claims with overlapping facts, then having a memo that really does a rigorous analysis of each, and again, it helps you also make sure that you are covering all of these important bases, as well as assuring the judge that that's what you're doing.
And thank you for reminding that, Trena. I wanted to say when we were talking about the new legislation, and I didn't, I wanted to make sure to mention that in part because we don't know what's going to happen with the new legislation, that we have the unlawful dissemination of an intimate image and identity theft and the doxing as these new contexts, and we expect to see pushback on some of that. Please reach out if you have a case involving one of those types of contacts and you want to talk about it. Let's make sure that if it is a case that's going to be challenged at the Court of Appeals, like we expect, that we have a good hearing memo, that we have preserved the issues, as Aaron said in the chat box earlier. Let's keep getting these cases in front of the court, and one of the best ways to in front of the Court of Appeals in the Supreme Court, and one of the best ways to make sure we do so is by making sure we're preserving the record. And wow, that's a whole lot easier to do by writing a hearing memo on these issues. So totally agree. Big plug for hearing memos.
We have two more questions. The first from Caitlin. I've heard of folks getting to the courthouse to self-file a stalking order and the clerks won't give them a SPO application and advise them to file a FAPA instead. Do y'all have experience with that? Any thoughts? Can it disadvantage a petitioner to have a FAPA petition denied and then apply for a stalking order?
All great questions. I will say that if the court clerk is not giving someone a form that they're asking for, then I would argue that's the unauthorized practice of law, and I might want to talk to their TCA. I'm not necessarily saying you say it in those terms, but please reach out and I'm happy to talk to someone or talk to you about how to carefully discourage, sorry about that, carefully discourage court clerks deciding what forms to provide. So I'll start with that. A lot of the forms can be e-filed now, a lot of the restraining order, though I don't think stalking, so don't quote me on that one, but they should not be saying what they will and will not accept as far as that goes. I do want to mention, though, this great, can it disadvantage a petitioner to have a FAPA petition denied and then apply for a stalking order? This is a really good question. We have a Court of Appeals case in which the survivor's FAPA petition was denied. She went and got a stalking protective order, and the other side tried to argue claim preclusion, which is a really great point, right? It's a legitimate concern, but the types of abuse you have to show are significantly different. In that case, it was very easy because, I think it was simple. It should have been obvious because the FAPA was denied because they were not family or household members within the definition of family or household members under FAPA. So the person wasn't eligible for a FAPA. But I will say it can get convoluted. It can get confused very quickly. I would just make it really, really explicit, right? FAPA, you have to prove that there was one incident of abuse, and abuse is clearly defined under the statute and includes bodily injury. It doesn't include this causing fear of apprehension of danger and personal injury, right? Now, if a court explicitly said in a FAPA, I find, if the type of abuse in the FAPA was placing someone in imminent fear of bodily injury, if that was the definition of abuse that someone tried to use in FAPA, and the court made a finding, I find that that did not place them in imminent fear of bodily injury, and then they try and use that exact one in a stalking protective order, then I think you're going to have some claim preclusion, issue preclusion problems. But I think it's, you again have to think it through. I'd be thoughtful about it. I'd again make sure to sort of clearly outline the different things you have to argue in each. But I don't think it's an automatic. If you're denied a FAPA, you'd be denied a stalking or vice versa. Trena, do you have anything to add?
I think just the really short summary of that is don't assume that it's going to get in your way, but don't assume that it's not, right? Just, you do have to do the analysis by parsing it out.
And then I saw the other question about, haven't seen a hearing memo in family court. Do you serve a hearing memo on opposing counsel by when? The answer is yes, we do hearing memos. We encourage hearing memos all the time in family court. And by when is your supplemental local rule.
Right. Yeah, I mean, and of course, one fairly obvious point is you serve it whenever you file it, right? Because that's what Rule 9 says that you have to do. And then, yeah, I think best practice that may or may not be reflected in the local rules I deal with, I think probably is like 24 hours in advance of the hearing, but double check the rules.
Great. Well, thank you again, Deborah and Trena and everyone who attended. I do want to mention that we will be applying for 2 hours of CLE credit for this presentation. And I took down all the attendees' names, and so I'll be in touch as soon as that's granted. And then you'll find the materials again on probono.oregon.org.
Thanks, everyone.
Thank you.
Thanks all.
Bye.